today's episode of May the Record Reflect.
And this is something I was told when I was a very new attorney. And that is, don't read from notes. Don't read your presentations. I had an older law partner who said, Sal, you know what? Don't use your notes. You're going to forget some stuff that you want to say. They're going to be on your notes and you're going to forget them. You're going to more than make up with that with the rapport that you make with your audience. And he was so right. And there's always things I forget. I'm saying, shoot, I forgot to say that. That's okay. It's more important to make that connection with your audience. It's more important to be able to look at the jury and talk to them about what's going on. And it's coming from your heart. You know, there's no way that if you ever fell in love with someone and you want to tell them you love them for the first time, you would pull out a piece of paper and say, I love you, right? You're not going to do that, because what's that going to mean to the person hearing that? They're just empty words. So yeah, speak from your heart. You know your case. You know these facts well enough, trust me.
That was Justice Sal Mungia, and this is May the Record Reflect. Hello and welcome to the monthly podcast of the National Institute for Trial Advocacy. I'm your host, Marcy Mangan, and in today's episode, I'm excited to introduce you to Justice Sal Mungia. He is one of the newest justices on the Washington State Supreme Court, and funnily enough, this is not his first time in service to the state Supreme Court. After graduating from Georgetown University Law Center, Justice Mungia clerked for a Washington State Supreme Court justice, much like himself, which he then followed up with by clerking for a federal district court judge, and then he joined the Tacoma law firm of Gordon Thomas Honeywell. During his 38 years with Gordon Thomas Honeywell, his practice consisted of complex civil trial and appellate work, including cases regarding general aviation air crashes, insurance coverage and bad faith claims, medical negligence and wrongful death claims, and commercial disputes. Justice Mungia also litigated constitutional law issues, including First Amendment freedom of speech, separation of church and state, and commercial and spending clause disputes. I am delighted Justice Mungia squared away a little time off from the bench to share with us the 10 essential things he would like you to remember about being a trial lawyer. Here's our interview. Justice Sal Mungia, I am so glad to have you on.
Marcy, I am so glad to be here. And it's just a little weird. You're going to call me Justice, even though you have always called me Sal throughout the year. So I know it's going to be a little weird for you, but I guess we'll work with it.
Well, you know, I've known you since before Anita even had this podcast. And actually, we met not long after I moved here to Seattle 13 years ago. And I've always looked forward to seeing you at the Seattle Trial Program. So it's very much a treat to have you here with me today.
No, Marcy, you're the best.
No, you are.
No, you are.
So last year at the Seattle Trial Program, I sat in on a plenary session that you ran as the program co-director. And it was a list of your top essential tips that you think every trial lawyer should know. And as I was listening, I thought, I think this would make a really fun episode for the podcast. And I'm really delighted that you agree. So you've got 10 essential tips for trial that you want to share with our listeners today. Shall we begin?
Right. And you remember that when I did it for our program, I think there was 25.
Yeah.
And I'm not sure whether they're essential. People, you can listen to them. If they make sense, great. If they don't make sense, understood as well. But yes, so this is a mini version of what the longer version would be.
Okay, let's start with number one then.
Number one. And as I go through this, let me just tell you, it's not going to be one of the tips. But as one of the things I do talk about during the program is the concept of recency and privacy. So people tend to remember what you say first and what you say last. So keep that in mind, because I'm going to start off with what I think is the most important thing. And when I end with what I think is probably the most important thing. Not that the others aren't important, but using the recency primacy model. So the first one is never lose your credibility, right? Never lose your credibility either with the jury or the judge. This whole trial game is a matter of trust. And if you start losing your credibility, the jury isn't going to trust you. And it's really hard for the jury because they're going to be hearing from two different sides. Usually the case, it's going to be presented by two really good lawyers, and the jury's going to be sitting in that box wondering, who do I believe? Who makes the most sense? So whatever you do, don't lose your credibility. And I've seen that done at times.
So how might you lose your credibility? Can you give some examples?
Sure. One is saying things that just don't make sense. I mean, it almost sounds like, oh, now you're making an argument like a lawyer would make. In other words, you're stretching the truth, you're stretching reality, you're stretching my sense of how the world operates. And you always got to sit back. I always tell people, put yourself in the jury box, put yourself there and listen to what you're saying. If you start making arguments that you're just thinking, boy, if you told anybody else, they'd be like rolling their eyes or shaking their heads at you. That's what you have to worry about. A good way of checking this, and what we did at my firm, I was in private practice for 38 years, we do mock juries, right? Just to find out what are the arguments that resonated with them, what didn't, because again, it's just what is the credibility? What is credible? What credible just means what is believable.
Mm-hmm.
And so you don't want to lose that credibility because you don't want to lose that trust.
Right. Okay, so that was the first essential tip. What is number two?
Two is just right up there with number one. Okay, and this is what a lot of trial lawyers, especially newer trial lawyers, don't know. It's what every good trial lawyer does know, is that you are telling a story. Not a made-up story. It is a true story, but it's a story nonetheless. That's how people really learn. That's how we understand how the world operates. It's through stories. When you think of the great storytellers of all time, Aesop's fables, or, even, I'm not going to put in any religion in this, but, you've got some great stories in the Bible, just the way that they're presented. That's the way we teach. And so that's the way you got to think about how you're going to present to the jury your story of what happened here. So it's not, here are the elements A, B, and C. These are what the facts are going to show, A, B, and C, and therefore our side wins. No, the story is, my client was harmed. My client was hurt. The doctor was incompetent, or the doctor did everything she could to save this life. Are you kidding me? She went out of her way, and this is how she did it. It's a story. People think more with their guts when they're deciding these issues than with their heads. I always give this example. One of the most famous TV shows, and certainly it was the #1 rated TV show for like over a decade, and that was 60 Minutes. And I'm not talking #1 rated news TV show. I'm talking #1 rated show in the country of all TV shows. And the originator of 60 Minutes, and of course his name escapes me right now, but told the 3 original anchors, here's what I want you to do. Tell me a story. And that is so powerful. And that's what it is. You watch 60 Minutes, you watch any good storyteller, it's at the very beginning, there's a hook right there, and you're engaged with that story. And hearing that story, you're thinking, yes, this person, at least in the context of a trial, this person should win, or this company should win, or this entity should win because of what the story tells you. And then, of course, you got to present the facts to support that story. But it's a story. And unless you understand that, you're going to be losing so much of your persuasive abilities.
So number 4, what is your fourth tip?
Oh, we could go to number 4, but I think maybe we should go to number 3 first. I think you were just testing me to see whether I was paying attention.
Yeah, that's the story. That's the story.
Okay, good job, Marcy. Number 3 is speak English. Speak English, speak English. Lawyers start talking, and I see it in legal writing all the time. And I used to tell my associates at the firm, and I have to tell the law clerks, if I see you using legalese, you get 1 free pass, but other than that, you're going to be buying me a latte. Herewith, heretofore. I said, do you use that in usual language? No, you don't. So that's how you want to speak. That's how you want to write. But definitely when you're talking to a jury, you want to speak, if you will, English. And actually, the level of English you're going to be using is about 10th grade level. So you're not talking down, you're not talking up to the jury. It's about a 10th grade level of English. So just talk like you would normally talk, because you're a storyteller. You're there just to tell them that story. And what's interesting, I think it was the Stanford Law Review wrote this article about 30 years ago. It's the 50 most misunderstood words by a jury. So I'm going to go over just a few of these right now with the listeners here, because I'm sure that the lawyers who are listening to this have used these words before a jury, because I know I have. The number one most misunderstood word is prior. Prior. People don't understand what prior means. 2, subsequent, right? So instead of saying prior and subsequent, can't we just say before and after?
Yeah.
Marcy, prior to the time that you logged on, what did you know? What did you do before you logged on? That's how we speak.
Yeah. I think that that also harkens back to point number 1, which is maintain your credibility. Don't do things to lose it. And if you start talking over people's heads, they're going to tune out and not listen to you, and there goes your credibility.
Exactly. It all keys to a lot of these when we're talking about goes to number 1, which number 1 and number 2 kind of go hand in hand. You need to be credible and you have to have a great story. But using words that people understand. I'll give you just a few more. The number 3rd one is relevant. 4th is relative. Number 5 is magnitude. Number 6 is erroneous. I mean, these are words that you and I use all the time, right?
Sure.
These are not the words that your average jury is going to understand. So it's that, it's a great magnitude. No, it's a lot of, you ever hear people say, oh man, they just eviscerated that argument. No, you gutted that argument. Talk just like you would at your local bar. Well, maybe those of you who go to local bars, I know what that sounds like. I go to my local bar and talk to real people. So speak English so that people can understand what your story is.
Okay. So now are we on 4? Is my counting right?
We're on 4 now.
Okay.
Yep. Okay.
All right, let's hear it.
And these tips are not just to be a better trial lawyer, but these tips are to be a better lawyer and, in my view, a better person. So just keep that in mind. I mix some of these up, as I told you before. I have 25 that I tell at our NITA program in Seattle. But number 4 is really important, and I point it out because I just think too many lawyers, more than there should be. Let's put it that way. There are more lawyers who do this.
I'm in suspense. Tell us.
And that is, don't be a jerk.
That's a good one.
Okay? Don't be a jerk. Oh man, lawyers have reputations of being jerks. People think you have to do it, and I understand, especially when you're a newer practicing attorney. You think you've got to be aggressive. You think that you've got to be harsh. Older attorneys are giving you a bad time, and you think that's the way to practice. It isn't. And I'll get to some of these, if you know what to do, you don't have to be a jerk. And if anything, kind of go the other way, which gets me to point 5, which will be in a second here. But I'm not going to tell you what point 5 is yet. And I know that's hard, but I really do want to get this message across now, especially the newer attorneys out there, but older attorneys as well. Take a look at yourself. Yeah, you could be a jerk, but if you're good enough, if you're really a good trial lawyer, you are going to be able to win without being a jerk.
Absolutely.
So and be a better person too, okay? Be a better person. Life is too short.
Well, I also think that it's uncomfortable to be the witness to somebody being a jerk. And so jurors don't like that.
Correct. And in fact, it's funny, just a minute, just interject this in, kind of squeeze it in. Believe it or not, in November, I was lucky enough to serve on a jury.
Oh, how does that happen?
Oh man, that's a time for another story, Marcy. We don't have time today. I know that on these 10 tips. But someday, especially when you and I get together, I'll tell you I was fortunate enough to be able to not to be excluded from serving on a jury.
All right, it's a date. So what was that experience like? Just briefly, as a juror.
As a juror, so mine was a little weird, right? Because former lawyer, now a judge. But seeing how the lawyers did not know enough of the practice rules that you really should know, seeing how they repeated themselves way too much. I mean, I'm just thinking, okay, I got it. I am not an idiot. And this is not just me. The social studies show that that's usually one of the top complaints of jurors is that they complain that attorneys tend to be repetitive.
So those are a few extra little bonus tips that you just snuck in there. Yes.
So bonus tips. That's right. That's right.
All right. Should we move on to number 5?
We should. So this is related to number 4. Show some grace. All right. And what I mean by grace, I'll remind people out there what grace means. It doesn't mean that you can walk gracefully. It doesn't mean that you can sing gracefully. Showing grace is giving something to someone that they don't deserve. Or if you're receiving grace, you are receiving something from someone that you don't deserve. Now, especially in this highly competitive profession that we find ourselves in, where if you're not winning, let me tell you, you're not going to survive in this practice very long. I mean, everybody knows it's a zero-sum game. You have to win. So there's a huge pressure on you to win. So like maybe number 4 and 5 are tied together. So you have a tendency to be a jerk. And there are some people who are going to succumb doing not just jerky things, but unethical things. Why I'm saying this is because you're going to suspect that the other side, their motives for doing something is because they're doing something unethically or just to be a jerk. But there may be another reason that they're doing that you have no idea about.
And that's where the grace comes in.
Correct, right?
Got it.
I mean, you have no idea what's going on in someone's life. So my thing is, people would ask me certain things, especially early on. If I'm on the plaintiff side, I always file my complaint, but with the complaint goes my first set of discovery. I want to have that first leverage over my opposing counsel because I know it's going to happen, usually because you get very limited time to respond. I'll get used to be in the old days a phone call. Now more times it's just an email saying, Sal can have extra time to answer the first set of discovery, can have an extra 30 days or something. So that's how you show some grace. Yeah, the rules are, you have 40 days to respond. I want them within 40 days. Yeah, that's a jerk, and there's no reason for doing that. You show some grace and say, of course, you need an extra 30 days, you got them. And I always did that. You need extra, because no one cares at the beginning, right? Or especially if they want an extra week. It's not like I'm going to read those things the day they come in. There are times when it prejudices your client. You guys say, as much as I'd like to, I can't, and here's why. But there are plenty of times that you can give people grace. I remember we had this case with one of my newer partners where every time we had a discovery dispute. In Washington State, you have what's called a Rule 26I conference. You have to talk with the other attorney about the discovery dispute. And then if you can't resolve it, if you're the moving party, you note up a motion. Every time they could not resolve, which is a lot of times, before he could even note up his motion, she would send him a notice of unavailability for like the next 3 weeks, so he couldn't note up the motion. And he would come complaining to me, say, Sal, this is ridiculous. I think we should go to, I said, no, Rob, you know what? You don't know what's going on with her life. We'll get the information sooner or later. We're still early enough. And like after the third time of her doing this, he was just going bonkers. I said, we're going to win in the end. Trust me, we're going to win in the end. Our goal is to win, right?
Did you win in the end?
Yes, actually, yeah. It's settled and they paid us what we wanted on the case. So
good job.
Yes. Yeah. No, my thing is I always knew I was going to win, right? I knew I was going to win. You can play games with me. I'll let you play those games because I'm going to give you the benefit of the doubt. But you know what? The game's going to end sometime, and at that time, I'm going to get what I want.
All right. That's a good tip for all of us. How about number 6?
Number 6. So this is one thing that we really stress at NITA. And this is something I was told when I was a very new attorney. And that is, don't read from notes. Don't read your presentations. I had an older law partner who said, Sal, you know what? Don't use your notes. Mm-hmm. And you're going to forget some stuff that you want to say. They're going to be on your notes and you're going to forget them. You're going to more than make up with that, with the rapport that you make with your audience. And he was so right. because every time I don't like using notes. There are kind of cheater ways you can do that by having diagrams, having charts that kind of keep you on point, but never reading from notes. And there's always things I forget. I'm saying, shoot, I forgot to say that. That's okay. It's more important to make that connection with your audience. It's more important to be able to look at the jury and talk to them about what's going on. And it's coming from your heart. So it goes back to that first point, your credibility, right? They're seeing me. I'm not reading something from a piece of paper. I'm looking at them and I'm telling them, this story, if it's opening or closing argument, if I'm examining my witness, I'm looking at the witness and I'm looking at the jury. If I'm cross-examining, I'm just looking at the witness. I tend to look at the jury on that. I want the witness just looking at me. But again, to build up that report, and you can't do that. You can't do that if you're reading. There's no way that if you ever fell in love with someone and you want to tell them you love them for the first time, you would pull out a piece of paper and say, I love you, right? You're not going to do that because what's that going to mean to the person hearing that? They're just empty words. So yeah, speak from your heart. You know your case. You know these facts well enough. Trust me. You know that opening statement well enough.
Yeah.
You can give it. You're going to forget some stuff.
Yeah.
You're going to make a bigger impact with the jury, though.
Well, I think that's a good reminder that you do know your case. You know it inside and out and up one side and down the other. And yeah, you might forget a few things, but nobody knows your case as well as you do. And you just have to trust that you'll hit all the most important things.
Absolutely. Absolutely.
Okay, so in no particular order, tip number 7.
And this goes back to kind of showing some grace. Don't be a jerk. You can do that if you go by number 7, which is kind of number 7 and 8. Oh, I should have made this into 1, but I'm not. 7 is play by the rules. So when my kids were growing up, either it's a blessing for them or a curse for them, but they grew up in a very competitive family. We played games all the time, and I never let up on my kids. And so what that meant was the kids, in order to survive, had to play by the rules, because they knew that if they weren't playing by the rules, I would tell them it doesn't count if you win. If you cheat, that's not winning. And they always knew that. They had to play by the rules. I'm thinking the same way with trials. If you have to cheat, you're not winning. You're not good enough. That's what you're telling yourself. You're not good enough to win by playing by the rules. And I'm saying you are good enough. It's a lot of work and it's tough. And there's no guarantee, even if you do all this stuff. Shoot, everybody knows that they've lost trials that you thought you're going to win and that you should have won. That's the nature of trials. That's the risk factor of having those 12 people decide your case. But I had enough confidence in myself saying, I'm good enough. I can play by the rules, and I believe I'm going to win. So it doesn't count, everybody out there, if you cheat and win.
All right. Essential tip number 8. So
this one goes with number 7 is you got to know the rules. Hard to play by the rules if you don't know the rules. You asked me, how it was like being on the jury, and I saw that some lawyers didn't know what I would think is some basic trial elements, so how to refresh the memory of a witness, and saw them fumbling around. It's funny because the trial judge, he and I have been friends for over 20 years. And after the trial got over, he said, Sal, you got a couple of minutes? And I said, sure, Stan. So I went back to his chambers and he said, well, what do you think? I said, well, there were times I was being driven crazy. He says, yeah, that's my life. I just see lawyers who don't know what to do, and I'm trying to help. I said, yeah, I saw that actually you were trying to do that. You've got to know the fundamental rules, right? You've just got to. That's part of your craft. If you don't know how to introduce a piece of evidence, you aren't serving your client well. If you don't know the rules of hearsay and the exceptions, you are not serving your client well, because hearsay is one of the major objections that you be able to either make or respond to. So you have to know. You have to know the rules.
Well, it's kind of funny to hear you talk about how you had this little informal confab with the fellow judge, and you both arrived at the conclusion that so many people don't know what they're doing in the courtroom, because that's actually how NITA came about back in the early 70s. A bunch of judges sat around this kitchen table kind of complaining about how, God, these trial lawyers don't know what they're doing. And they came up with case files and and the NETA method and taking the show on the road.
Well, it's from the 70s, even back then, being able to get jury trial experience was very difficult. It has only gotten more difficult as the years have passed. So it's hard getting into the courtroom, Marcy. So unless you get in and practice this stuff or even know what to do, or you have a good mentor, that's why you see this deficiency. It is tough.
Yeah. All right. Well, we're getting close to the end. We're at number 9, but after we get through number 10, I want to talk about some of the ways that you can get trial experience. But let's get to number 9 first.
Number 9, be yourself. It's that old kind of cliche, be yourself, because that's the only person you can be, right? But, I've seen so many people, so they see like a really great trial lawyer, someone, a great advocate in court, and they're trying to be like that person. But you're not that person. You're you, right? I mean, I know I'm me. I'm a little, at times, over the top, right? I'm a little emotional. I tend to
That's true.
use a little bit of energy in my presentations, but that's me. That's me. That's, if that's not you, don't try to do that, because that's not you. But just some great lawyers are just very more even keeled, more matter of fact, soft spoken, and it works for them. You've got to know the basic techniques. You have to know how to be, if you will, a storyteller. All those techniques are the same, but how they're told are completely different. I hate to show my age, but two great comedians, Bob Newhart had a completely different style than, let's say, Chris Rock. They're both hilarious, right? And so they're both practicing their craft of comedy, but they're being themselves. And that's the same thing with trial lawyers. And I can't stress that enough. You've got to be yourself. Figure out how these tools work within your personality and then use them. But don't try to be somebody that you're not.
Yeah, and that's hard to sustain also. Okay, number 10, the last essential trial tip.
Which is my theory in life, right? Is number 10, have fun. Oh my gosh, if this is not fun for you, maybe you should not be a trial lawyer. I'm not kidding. And I understand it's going to be nerve-wracking.
Yeah.
There's going to be so much pressure on you. But at the end of the day, you've got to have fun doing this. And I'm not telling you, Marcy, every time that I tried a case, when I was in trial, I was thinking, this is the best thing ever. I'm not kidding. I am just eating this thing up. I'm loving this. This is my chance to be creative, to be able to tell my story, to represent my client, to use my wits to figure out, whether I should object. If I do object, how do I make that argument? How do I use my exhibits? It's just so much fun. And it's so nerve-wracking when you're waiting for the jury, right? That's when it's just tension-wise. But I always thought this was great. I can't think of anything that I'd rather do. Now, having said that, I've joined the bench, right? But that's to try to hopefully make more of a difference for our legal community and society. But having fun, I'm still having fun, and that's the way life should be. Got to get things done, but you should have fun.
Yeah, agreed. I love that. And I've heard from so many trial attorneys who say, I could never, ever do transactional work. I would die of boredom.
Yeah, I'd be right up there with them.
All right, so we've gotten through our 10 trial tips, and you said that you actually have 15-ish more. How can listeners hear the rest of those trial tips?
Let me think. This just came to me. They could come out to Seattle in August when we have our trial skills program. Oh, gee, why didn't I think of that before?
What a great idea. I have to say that as a resident of Seattle, something that people don't realize is that Seattle is actually the very best place in America to be in the summertime.
I was going to say.
Not just learning trial skills, but also just being here in the summertime. Absolutely gorgeous.
There's no better place. I have to say an amen to that, Marcy. As you and I both know, August in Seattle is just gorgeous. It's not the summer heat. It's not the humidity that you're going to face on the East Coast. It's just pure paradise in August.
Yeah, you can walk to your car without being cremated on the sidewalk. You can actually go take a run and a hike at 3 o'clock in the afternoon and not die of heat stroke. and it's dark, green, lush vegetation, flowers are in bloom, sparkling waterfronts, everything you want and more. And the more is Seattle Trial Program. What are some of the special things that you have at the trial program that you might not find at other NETA trial programs?
Well, I'm not sure if other NETA programs do this or not. I know at least some do, but we're going to have actual jurors in. So on the last day of course, we do mock trials, and this year we're going to have jurors in there to deliberate. So that's going to be one. Two, usually on trial date, we have actual judges being the judges. So not just lawyers who are great instructors who can be great judges, but we have people from the bench doing that. Three, we have a judge, again, longtime friend of mine, in King County Superior Court, which is in Seattle, that Judge Keenan holds court on the pretrial matters, and he does such a great job of it. I mean, we're all in there together. People are making their motions. He does a great job, and we always get great feedback about that. Four, we're going to have a speaker, and of course, you know her name, and then I can't remember her name. Who's
Lori Gilbertson.
Lori Gilbertson, who has expertise in how to do oral presentations, to how to become a better public speaker, how to become a better trial speaker. And she teaches throughout the country. So we've already reserved her months in advance to come out to Seattle. And then finally, fifth, which may be different, we're going to have an ethics credit, and hopefully it's going to be a diversity credit for those Washington lawyers who need a diversity credit. That's pending approval, or will be pending approval, a 1 hour ethics credit during our program. So in addition to learning the rules, learning how to do an opening, closing, cross-examination, how to get a piece of evidence into evidence, you're going to be also getting these other extras as well.
So if you are interested in coming to hang out with Justice Sal Mungia and his co-program director, Nick Williams, who is a wonderful trial attorney in St. Louis, check out the show notes. There's a link in there, register, and we'll see you there. Sal, Justice Mungia, before we sign off and we let you get back to doing the people's work for the great state of Washington, final question. What have you been watching on TV or in the movies lately?
Ooh, there was this movie I just loved. Oh gosh. You did, only because I can't think of titles anymore, but it was the trial of the Chicago Seven. That's what I think is the movie title.
Oh, I put you on the hot seat.
Abby Hoffman, but it was the 7 defendants during the 1968 protests at the Democratic Convention. What a great movie. It moved my soul, because again, people are fighting against injustice, putting themselves out there, putting their physical safety at risk, taking on unpopular stances to promote justice.
All right. Well, that's a great place to end. I'll leave the link for that in the show notes too. Thank you so much for joining me. This was a really fun episode, and it's always a delight to see you.
Oh, Marcy, so much fun with you.
May the Record Reflect can now be heard on YouTube. Now, do we have a cushy recording studio where you get to watch me on video, sitting face to face with the latest guest as we discuss all things trial advocacy? No. In fact, I record these episodes seated on the floor of my closet, as I am right now, because as it turns out, clothing makes for good acoustics. But if listening to podcasts on YouTube rather than watching them is your jam, you can find us under @NETA Videos, which is one word. In any event, and however you listen, we at NETA are so glad you do. Until next month, we wish you the very best of luck in your depositions, motions, and trials. Happy lawyering! May the Record Reflect is a NETA Studio 71 production. NETA. We are advocacy enhanced, mentorship reimagined. Welcome to the community.